Joining us now, two CNN legal analysts, defense attorney and former federal prosecutor Paul Callan, and Shan Wu, former attorney for Manafort associate Rick Gates. Always good to have both of you with us. So, I brought this up this morning because I wanted to make sure I'm not an idiot in asking this question. But when I saw the answer that the judge gave in terms of redefining reasonable doubt, he said prosecutors must prove the case, in this case, not beyond possible doubt, but beyond doubt based on reason. Paul, can you put that in English for me?
Well, this question of whether the definition of reasonable doubt scares prosecutors to death because it makes them think, well, the jury thinks there's reasonable doubt in the case. A lot of times, by the way, it's just one or two holdout jurors, and they just want to hear the definition. So it may not be such a bad question in the end. But the courts are very careful in defining it because the Supreme Court and other appellate courts across America have said the term is reasonable doubt. Don't be attaching your own meaning to it. So a lot of times judges just flip it and they say it's a doubt based on a reason. Sometimes they'll go, if the question is re-asked, they'll say, you have to prove guilt to at least a moral certainty. There are some other phrases that are used, but he's starting out with the safest instruction to the jury, which tells them nothing.
Nothing at all.
Right.
So when these four questions came in, Shan, I think the response from Erica Hill and me was, as Erica just put it, and I knew when you heard them as well. You said, this is not going to be, a sound sleep tonight for the prosecution team. Part of it is the timing of the reasonable doubt questions.
That's right. I mean, Paul's right. That's the bane of defense counsel and prosecutors and courts is that definition. It's a very unhelpful definition. But the timing, I think, is critical here. It certainly is not uncommon for that question to come out. It does usually indicate there's a holdout or some dissension. And what's alarming for the prosecutors is how quickly that note came out. They barely have begun deliberating. Typically, you wouldn't reach a question like that until there's been some kind of preliminary polling within the jury and somebody is concerned and may be holding out already. So that's why, as a prosecutor in the case, I would be very concerned that it's coming out at such an early time.
And then also, Shan, the two of the other questions had to do with arguments. Some think that the strongest arguments the defense made during the trial, it's almost as if the jury is posing the question on the defense terms.
Yes, that's right. I think, again, that's another alarming point for the prosecution is the question about both the shelf life, which was a phrase that Gates used. A lot of people are thinking it's a misspelling of Shell Corporation, but it's actually a phrase about putting a company on the shelf. And also the question about the banking and disclosure regulations. There's a pretty good cross-examination point for a FinCEN agent where they basically admitted that it was possible that Manafort might not have needed to register because it's a little bit complicated, but his corporation owned a foreign bank account, and under those circumstances, it's possible maybe he did not have to register. So that's an important point for the defense there, and it's interesting that the jury is honing in on it so quickly.
As all of this is playing out and we're waiting for day two to see what happens, we also learned in a court filing yesterday that the prosecution has 3 times the amount of evidence for this next trial that Paul Manafort will be facing. A, should we read anything into that, Paul? And B, what's the real difference here between these two trials?
Well, there's a big difference. This trial is taking place in Virginia, in a county that at least has a lot of areas that voted for Trump. So the defense, I think, thought they might have a better shot at an acquittal in Virginia, as opposed to Washington, D.C., where if you look at the voting numbers, of course, the president is not very popular. However, the complexity of this case in Virginia is really overwhelming. I mean, the second question the jurors are asking is about shelf corporations and, whether you have to file tax returns regarding an account in Cyprus. I mean, they're examining things like this. The good thing for the prosecution is they want to look at the pictures now of the ostrich jacket and the python coat and all of the other luxury items that Manafort had, which I think prosecutors were using to try to simplify the case and say, hey, he's living way beyond his means, so he filed false tax returns. In Washington, however, totally different charges. Failure to register as a foreign agent is the primary charge there, and money laundering. They're simpler charges, easier charges for jurors to understand.
No ostrich.
Although it's not an easy case either. It's not an easy case either. And I think, frankly, a lot of people have undersold the political ramifications, the political side of this. if Paul Manafort is acquitted, because I think that Rudy Giuliani and the president will jump all over this.
Absolutely.
And I think you could, Shan, I think presumably see the president move to pardon Paul Manafort. It's not impossible that he says, look, this jury just acquitted him. Why should he have to sit for another trial?
Oh, absolutely. That could give him a good bit of leverage to use from that point. And to Paul's point, it is a very different case in D.C. It was a big strategy call on the Manafort's camp to refuse to let the cases be consolidated. And again, just based on public information, nothing insider from my former representation, they could have consolidated both cases in D.C., but they made a call to want to break it up, make the government go twice, and pros and cons to that, but no question it ratchets up the pressure on the outcome of this first trial enormously for both sides.
As all of this is going on, there's new reporting from the Wall Street Journal about Michael Cohen and this payment to Stormy Daniels, which we've all spent a lot of time talking about, that this deal actually came about. They'd been approached, according to the Journal, in September. The Access Hollywood tape is released. The next day, all of a sudden, Michael Cohen is open to a deal after initially sort of balking at the idea. Paul, just your thoughts on that?
Well, the lingering question, getting back to the Stormy Daniels payment, is whether it was illegal. Of course, you can, I mean, it may be
campaign
unseemly.
funds.
That's right. But it may be unseemly to buy the silence of somebody, but it's technically legal in the United States, unless it's a campaign violation. The timing here now and the issue of Trump being in trouble because those comments on the bus would suggest that an analysis was made, hey, he can't take another hit on having an affair with a porn star. We better buy her silence. That might make it a campaign violation and possibly criminal in nature.
And Shan, when I read this, you know who I thought was in trouble is Michael Cohen. And this could give us a window into all the news we've been hearing from his camp about willing to cut a deal here. It just does seem like prosecutors have a lot to go on in terms of just getting him if they want to.
Yeah, and I agree with Paul there. The timing is what comes into focus with this. I mean, if he didn't become interested in negotiating until that tape came out, it really, again, ramps up the notion that this was much more related to the campaign than the president's camp would want us to think about. And that definitely puts a lot more pressure on Cohen to have to come clean about that.
Shan Wu, Paul Callen, fascinating legal discussion this morning. Man, is the next few hours going to be interesting.
Who knows what Monday will bring?